Hey everyone, welcome. This is David Brannen, lawyer at Resolute Employment and Disability Lawyers. Welcome to our daily live stream where I answer your questions about disability and employment law. Today is Tuesday, so it's our day that we focus on long-term disability, and I'll do a brief presentation here in a second. But after that, you certainly can ask any questions you want. I'm just here to try to help people and get your questions answered. So before we get started, I'll just let people know tomorrow we are doing our live stream. Tomorrow is about employment law issues, and I'll be discussing what is severance pay, what's involved with it, how's it calculated, so that you can kind of have a broad overview of what's involved if you get terminated from employment and are owed severance pay. Thursday is our open day where we just take questions, and also people have the option to come live, call in live on the show. You won't be seeing people won't see you on the screen, but they'll be able to hear you. You'll just basically phone in and I'll take your phone call and we will do a consultation over the phone, but it is public. So keep that in mind if you do want to call in. Friday, I'm happy to announce that I'll be having Lisette LeBlanc, who is a long-term disability lawyer here at Resolute Legal. She'll be joining me as our guest, and she and I are going to be talking about mediations, everything you want to know about doing a long-term disability mediation from the perspective of a client's perspective. So your perspective, not from necessarily, we're not teaching lawyers about this. We're going about it from your point of view of what to think about, what to know, the kind of good and bad about mediations in long-term disability. All right. So just a reminder, this is a question and answer show. How you put the questions in is just by typing it in the chat, whether you're on YouTube or if you're watching on Facebook. Just put the question in the questions chat area in the screen in front of you there. Put a Q in front of it so that I know it's an actual question. Sometimes people are just commenting on things in the chat. It helps me to be able to pick out the ones that are actually questions if you put a Q in front. I think that's all. So we're going to get started. As you know, I do the presentations I later clip these out and they're going to be posted on our YouTube channel as a standalone video. So you're just kind of seeing behind the scenes here a little bit. So I will do another opening for that YouTube video from when we clip it, and you guys can all be along for the ride. Now I'll work through the presentation. If I see there's some questions that are relevant to this part of the presentation I'm at, then I'll pop those up and ask them. Otherwise, I'll wait and take your questions at the end so we can get a clean take of this presentation, so when it's later put up on YouTube. This live stream will also be available on YouTube forever, so you can always come back to this, or you can go and find the clipped video that'll just be on today's topic. All right. Whew, take a deep breath here and let's get started. Hi, everyone. Welcome. I'm David Brannen, lawyer at Resolute Employment and Disability Lawyers. Today, we're going to be talking about what you need to know when returning to work after being on an extended long-term disability leave. Now, this is a crucial topic, whether you are feeling pressured by the insurance company to return to work or whether you want to return to work on your own terms. So what I'll be going over today is a presentation going over practical steps that you can use to protect yourself. Let's dive in. So returning to work is really one of the most sensitive moments in any long-term disability claim. It's an emotional time for people. It's legally risky. And what you do or don't do can have a big impact on your benefits and whether you keep them or lose them. That's why it's important to have a clear strategy and to understand your rights and responsibilities before starting any return to work process, whether it's initiated by the insurance company or you. All right. Now, this may apply to some of you. We're going to go through the common scenarios. I'll just review them first, and then we're going to go through each of them in more detail. But these are the common scenarios that we see. The first one is pretty obvious. This is where the insurer pushes you back to return to work, even when you don't feel physically or mentally ready to go. The second scenario that we see is when people feel ready to return to work, and they want to initiate that process, but they're scared in doing so will end their benefits, or if it fails, then now they can't get back on benefits. These are kind of concerns that they have. There's other common scenarios where there are a graduated return to work. That's where you return to work you kind of phase back into work, starting at a lower amount and working your way up. There are situations that come up where there's employer pressure to return to work and the insurance company and your doctors disagree. So that creates a weird situation as well. That's another one of these return to work situations. And finally, oh no, not finally. There's one more where you can change. You're returning to work, but you're not going back to your former employer. You're having to change your career or look for new work. So that presents a unique set of challenges. And finally, the big one is these return to works often are forced by the insurance company at the 2-year definition when your policy goes from covering you from any occupation, from your own occupation into any occupation. All right, now before we go through each of these scenarios, I want to go over some key legal principles that you need to be thinking of. So these are practical considerations and key legal principles. So for most LTD policies, they require you to follow your doctor's advice. This is a requirement of the policy. So if your doctor says you should try to return to work, then you pretty much have to do so. Otherwise, you are technically in violation of the policy. Second thing to keep in mind with return to work is the idea of a duty to mitigate. This is a legal duty that requires anyone in a legal case to minimize their damages that are arising out of the legal case. So in your case, that means you have to do everything, you have to give reasonable efforts to try to return to work. So usually it's better when trying to prove that you have mitigated, it is better to show that you tried and failed than not to have tried at all. Because the whole idea that you didn't try in and of itself can just on its face be seen to be a failure to mitigate. If you try and fail, well, it shows that you did try. The insurance can argue that, oh, they didn't try hard enough or this and that, but at least you tried and failed. It'll be easier for a judge to give you the benefit of the doubt. And the last part to keep in mind, before the last part, there's credibility. I don't want to miss that one. So credibility is the key factor in most of these long-term disability claims because so much hinges on you being believed or not believed. A lot of things can't be proven objectively. So no one can see your pain. No one can know how difficult your fatigue is. You have to be believed or not believed. So doing things that make you a believable, credible person are always going to be when in doubt, do the thing that makes you look like a credible, believable person. So acting in good faith through these return to work processes, even when they're difficult, shows that you are a good faith actor and that you're more likely to be believed and given credibility on other issues related to your case as well. Finally, this last one is a bit of an unusual thing that I recommend that you might not see from other lawyers, although it's possible they would recommend this as well. But part of it comes from my background as an occupational therapist before I was a lawyer, but I highly encourage you to engage return to work vocational specialists when doing a return to work. You can ask the insurance company to hire one of these people, or I've even recommended people go hire their own. This is someone who coordinates the return to work process and will coordinate between you, the insurance company, your doctor, the employer. They set out a plan, and they're the glue that kind of holds it together. Otherwise, these whole things can collapse and fall in on themselves because no one is talking to anyone. And if things fall apart, no one's responsible. And that's the worst case scenario. And that can be avoided by having a return to work expert. Some insurance companies will get them. Some will refuse. Again, if you ask for a return to work specialist, this helps your credibility. It shows you're trying to mitigate. And if the insurance company denies getting one, that looks bad on them. They're not helping you. If you fail in the whole process, well, they didn't even, they can now be blamed because they didn't even pay to help facilitate the process with what everyone would agree to be the best practice, which would be having a return to work specialist involved. Okay, let's go to scenario number one. Let me just grab a quick drink here. Okay, scenario number one is where you feel pressured to go back to work before you're ready. This is a very common scenario in which most people contact us looking for ways to get out of it. The first thing to know is technically the insurance company cannot force you to return to work if your doctor doesn't support it. However, it doesn't mean they won't stop payment of benefits. It just means that you have a medical justification for for not doing the return to work, and you could possibly be successful later by showing that you followed reasonable medical advice to not return to work. So what you need to do here is you have to handle this very carefully. It's not simple enough to have your doctor just say, yeah, sure, I don't think you have to go back to work. You're not ready. There has to be a lot of substance to it if this was going to stand up. And if you are going to rely on your doctor's opinion not to engage this process, it has to be well thought out. And the doctor would have to be able to give very good reasons and medical justification. That's what's always usually missing here. So what I would still recommend is that even if you are considering relying on your doctor to not do the return to work, I still would urge you to engage the process to some extent to get more information about what the insurance company is looking for in the return to work. What would the employer be looking for? What would it look like? Then bring those further details to your doctor and have them that way when your doctor gives an opinion, it's much more informed and likely to hold up in court later on. Now, what you would do is in this situation is you would have your doctor submit the objections in writing on why the return to work is not feasible. That's easier to do, like I said, if you have more details about what is involved. That can even include engaging a rehabilitation specialist, especially if you think you don't want to go back to work. Engaging a rehabilitation specialist is usually the best move because they may recognize and then they will speak to your doctor. And it's easier to have them talk to the doctor to better understand where the doctor is coming from. They may even recommend the rehabilitation specialist that it's not appropriate for you to return to work. So this is why I highly recommend getting them involved. All right, let's look at scenario number 2. And I'm happy to answer questions people have about scenario 1 because this is the most common and where my advice is usually that people do more to engage the process than they are intending to. Let's move on to scenario number 2. This is where you want to return to work. You want to initiate it. So it's you saying, okay, I would like to return to work. Right now, my benefits are being paid. The insurance company's not bothering me, but I really don't. I want to get back into the workforce. The risk here is real that the moment you start trying, the insurance company will cut off your benefits. And if you flounder around and you can't get a job or the job doesn't work out, that you may not be able to get back on benefits immediately. That is true. And so you do need to, that is a real fear. So definitely keep that in mind. The key in this kind of situation is to control the process as much as possible, again, by getting it structured, ideally through hiring a rehabilitation specialist. So, like I said, if the insurance company is initiating it, it's good to have a rehabilitation specialist. If you're initiating it, it's even more important to have a rehabilitation specialist. So if the insurer won't provide one, and they may not in these situations, then you really should consider investing the money to get one to help you assess the situation and provide guidance on this return to work. This will keep it more structured and it will make it harder for the insurance company just to cut off your benefits. And if the return to work is not successful, you have a professional there giving an opinion on that as well. And it will make it easier for you to get back on benefits if necessary. What will happen is when you have your own professional, if need be, they can submit a plan to the insurance company and the insurance company can approve it. Again, the more structured it is, the harder it is for an insurance company just to cold turkey cut you off. And also it will stand up in court later to show that you went about this in a professional, good faith manner. And if the insurance company with all of this kind of structure in place just cuts you off and says, nope, you wanted to try where you think you're done, it'll be very hard for them to have that stand up in court later. So this is how you would control the process, involve your doctor, involve a return to work specialist, and have it documented. The other thing I forgot to mention in both of these scenarios, if you are doing the return to work, you want to document things and keep a diary of how things are going. That way you're able to prove if it is unsuccessful, you can prove why it was unsuccessful. Now, one of the things, I don't want to get ahead of myself here. Well, I'll mention it now. I don't want to repeat myself too much, but one of the things to think about is conflicts with your employer during these return to works. A conflict with your employer where your employer is not is not doing their, fulfilling their duties or their obligations is not a reason for the insurance company to keep paying you. That now becomes a dispute between you and the employer. So I find that there are some people that really think that if they emphasize how bad the employer is and is undermining the whole return to work process, that somehow is going to help them stay on long-term disability benefits, and so they overemphasize it. That is not the case. You do not want to overemphasize that, blaming the employer. If that happens, the insurance will say, great, you've got a bad employer. That's take that up with them. We don't have to pay you. If you had a reasonable employer, you would have been able to go back to work. So be very careful about that, because sometimes you can have a situation where you have an unreasonable employer, but you never would have been successful with this anyway, even if the employer was accommodating. So you don't want to shoot yourself in the foot of trying to blame the employer for the failure of this return to work, when really, even if the employer had been more accommodating, it would have failed anyway. That is where you have to be very careful. All right. There is this final point here about the recurrent disability. Recurrent disability protection refers to a part of long-term disability insurance policies that allow you to go back on your claim if your disability recurs within a certain period of time. What that means in these return to works is that if you return to work and you have to go off work again for the same disability because it worsened within the period of time covered by the recurrence clause, then you go back on the same claim. You don't have to apply again. You just restart back on the same claim. That recurrence clause under most group policies is usually 6 months, but it can be longer or shorter. You have to know what your own policy says. But the recurrence clause is very important. So you would not want to, for example, go to return to work, struggle, know that it's going to fail, and have it fail 6 months in one day, right? If you fail 6 months in one day, you cannot fall under the recurrence clause, and you would not be able to make a new disability claim because you are no longer actively at work. So it can create a real mess of a situation where, well, I shouldn't say that. You still might be able to make a new disability claim, but you'd have to start over. But if you're not at the same employer that you had originally, then you wouldn't even be able to make a new claim. So there is a real danger of failing. If you're going to fail, you need to fail before whatever the recurrence period is. Do not push yourself so that you fail 1 or 2 days after, because you will shoot yourself in the foot and now you've lost the ability to go back on the claim. So knowing your reoccurring disability period is extremely important with these return to work situations. All right. So structuring a safe return to work. This really comes down to what the medical evidence says, okay? So if your doctor isn't on board, you should follow medical advice and not proceed with a return to work. However, there's a difference between a doctor not being on board and you telling the doctor you don't want to do it and them being busy and just agreeing with you. That is a very different thing. And don't confuse one for the other. It has to be a situation where you want to do it and the doctor is saying, no, you can't. That is a situation where it would be unsafe to do it. It can't be a situation where you don't want to do it and the doctor just shrugs and says, sure, I agree with you. Why not? And just they're busy. They're not putting a lot of thought into it. Sometimes it's very dangerous to present both situations being the same. Again, I go back to using a rehab coordinator and getting them to do a gradual return to work process. The best practice for someone who's been out on an extended disability leave is not to just come back and go back like day one, full duties. Here's your 2,000 emails, the 3,000, whatever that you got to catch up on. That is not the best case. The best case is to gradually return over a period of weeks, building up to full time. Now, that's usually because people returning to work still have maybe some limitations, and it's not easy just to be thrown right back completely into the deep end. That is something why it's advisable to work with a disability coordinator and figure out what makes the most sense. I already mentioned this, but during the return to work, keep a diary of your symptoms and flare-ups and difficulties. Go to the doctor if you're having problems. Get it documented. Document. Very important to document how things are going. So if it later turns out that you are not capable of doing this, you have some proof of showing over time what you were doing, what you're trying to like fix to stay at work. And ultimately, if it doesn't work out, you have a paper trail there. Paper trails, it seems like, well, we're just doing this for the purpose of a disability claim. Yeah, you are, because unfortunately, like that is the only thing we can get is paper trails. As long as it's honest paperwork that you're creating, then there's no issue with it. And it will help you if this becomes a dispute, because you can anticipate this will be a dispute. It can be a dispute that you're saying, what's a common thing is people will go back and they start out in the graduated return to work and they're working, say, part-time, and they can never progress beyond that. They're able to eke it out part-time, but can't progress past it. The employer is now paying you for part-time. Eventually the insurer will stop paying you. So now you're just getting part-time income. You're back to work, but part-time income. That presents a real difficult situation. And you would want to, if you feel like you're not capable of progressing past part-time income, you should see a lawyer, work out the math and figure out, okay, should the insurance company still be paying me something in addition to what I'm earning? They're going to say they don't want to pay. Insurance companies outside of private policies that have specific clauses for residual disability and partial disability, outside of that situation, group policies don't have that for the most part, and they are not going to want to pay you if you are back at work in any capacity. They will just take the view that you should be able to work more, and we're not going to pay you. That doesn't mean you can't bring a appeal or a lawsuit against them for them to top up your payment. It's just that they're not going to do it voluntarily. Okay, let's look at some common mistakes to avoid. So the big one here would be going back without your doctor's blessing. That's a big mistake because it shows you're not following medical advice and it could put your whole claim in jeopardy. It's not the worst thing in the world because I would rather see someone who is showing a good faith effort to, like, you're less to be faulted for that than if your doctor, obviously if your doctor's advising and you're not going back, that's a much different thing. And that is really the biggest problem. If your doctor is either neutral or recommending you go back, then you have to go back because otherwise it's a breach of your insurance policy and they can just terminate it based on you refusing a return to work. That in and of itself can breach the policy and give them grounds to terminate your case. And again, that makes it very hard to appeal because if you are terminated off of a claim based on a failure to do a return to work, like, what are you going to appeal? You're going to appeal that it wasn't reasonable to do a return to work, but you could get to court and a judge could say, yeah, we think it's reasonable that it was reasonable. It wasn't reasonable to do this. You should have. Now, like, that is a difficult thing to appeal. You're not even appealing the merits of whether you're disabled or not. You're appealing over this other thing. So don't fall into the trap of having them be able to get you on that one. I guess the other big mistake would be not giving reasonable efforts. This is why most people call us, because they want us to affirm their desire not to really go ahead with this. And unfortunately, I often have to give the opposite advice is that it's not necessarily that you have to do 100% of the return to work and actually do it, but you do need to engage the process so that you can get more information, that your doctor can give a much better informed opinion that it is not reasonable for you to do this return to work. What that means, when I say engage the process, I mean try to get a rehabilitation coordinator, meet with the employer to see what it would look like, have the rehabilitation person discuss what your capabilities are and whether that's a match for your employment, get a schedule of what it would look like. Then, based on all that information, have your doctor take a more firm stance that they don't want you, to do this. Or maybe your doctor, after all this, will want you to try. And then if that's the case, you do have to try. Doesn't mean you have to stay there the whole time, but you would need to document it. And then once your doctor said, you know what, you've tried, you gave a good faith effort, but this is just not reasonable for you to do, I'm going to take you back off work. That way you're rock solid protected. Yes, the insurance might still cut you off, but you have a very strong case now to get this overturned on an appeal. I don't know, assuming the insurer is on your side, believe it or not, some people will not necessarily, they will kind of think this way, that the insurer is they're recommending this, so things have gone along okay so far. So don't ever assume that they're on your side. It's probably not a huge danger of that, but it does come up from time to time. So just keep that in mind. Okay, I've already talked about the reasonable steps, because that is usually the one where people want to get around it. And again, I am understanding of it. I don't want to sound like I'm being not understanding, but people don't want to take steps because the whole idea of it is so overwhelming and embarrassing. Like there's so much tied up into it. You don't want to have to go back into a workplace with coworkers. They're going to see you in a different, there's a lot to it, but taking reasonable steps doesn't mean you go the whole way of actually going and showing up and doing the return to work. It just means you're engaging the process, learning more information so your doctor can make a more informed choice. I've given this example before. What you want to avoid is your doctor being busy and just agreeing with you with very little information about what it would entail for a return to work. Just agreeing with you, like they're a doctor who's agreeable. They just say, you know what, if you don't feel like you're ready, I'll support you in that. That's all fine. The problem happens later if it won't stand up in court. Your doctor will be called as a witness in court, and the other lawyer will start cross-examining them on why they advised you not to try the return to work. They will say, well, did you know this? Did you know the employer was going to allow them to work part-time? Did you know the employer and the insurer will come up with all these fantastic things that they would have done to make this work out, even if it's not true. They'll come up with these things and put them to the doctor and say, hypothetically, if we'd have done all this, why wouldn't you have recommended it? And they'll get to the point where it'll be ridiculous for the doctor to say, yeah, I guess they could have tried. That's when your case is over, when your doctor later will admit on the witness stand that, yeah, it would have been okay for you to try. Case over, go home, we're done. You have to avoid that happening in your case. The only way you can do that is to make sure when your doctor made the opinion that you can't do this, stuff was nailed down. Just to go back again of why it's important to engage the process and get a rehabilitation coordinator, they put the structure in place of this is what it would look like to do the return to work. And people have to commit to things. So the employer is committing to things that they can't change later. So once they commit to these things, like it would be this times a week, we would have this sort of help, there would be this other thing. There's a structure there and people have made commitments to it. They can't then later just make things up when you go to trial and put these weird things to the doctor and say things that they never would have done. Again, I'm just saying they will come up with scenarios that they probably never would have done, but you can't prove they wouldn't have done them. And now your doctor will look ridiculous, or they will have to agree that it was with all these ridiculous accommodations that they would have allowed. It will be impossible for the doctor to say, well, with all that, yeah, of course they could have tried. Take that scenario away. You do not want any chance of that. You take that away by having everything nailed down on what it was going to look like, have your doctor make the opinion on that, and then you're protected if this ever goes to court. Okay. When to seek legal help. So things can get complicated, especially if your doctor and your insurer are kind of fighting back and forth, or God forbid, the employer is objecting to things. It can get very complicated here. Seek legal help if you need some guidance, but for the most part, my legal advice is going to be you need to engage the process. You really should try to get a rehabilitation coordinator, get the insurance to pay for it. If there's any possible way you could pay for it, then you should try to do that. And the best part of the legal advice is going to be trying to prevent you from doing things now that will shoot you in the foot if you have to appeal this. Because certainly if you don't do the return to work, you're going to be cut off. So it's all about how do we set this up that gives you the best chance of winning on an appeal? All right. Final thoughts, call to action. So you don't necessarily have to go this alone. Get legal help, get a return to work coordinator who's working on your behalf. You want to protect your health and your claim. So protecting the health just means you are going with medical advice. Don't go back to work if it's going to be dangerous, either physically or mentally. But make sure that is documented. You can always contact us for help. There's contact information for us down in the description area of this video. We do have a return to work checklist that you can get. It's not downloadable, but it is available at our office along with our other stuff. All righty. with that, I'm going to take some questions. It looks like I do have one here. And if people have any others, I'm happy to take them. So let's get to our first question right here. If I get a multi-million dollar inheritance and home, must I disclose this to LTD or CPP? Well, that is an excellent question. Multi-million dollar inheritances do not affect LTD and CPP. They do not. It would affect things like the Canada Disability Benefit. It would affect things like ODSP or provincial disability. It would not affect LTD or CPP at all. Just isn't a factor. You can, like I said, if you have these things, they're just a contract that covers you in the event of disability. It doesn't matter if you're a millionaire or not. Everyone's entitled to what is allowed under the contract. The only things that can be offset are income, and income will be defined within the long-term disability policy and CPP. Income includes active income that you're earning through efforts at work. Million dollar inheritance and home is not that, so they would not be affected at all. Okay, does anyone else have any questions? One of the things I was going to look at for today, I did not have time because the day kind of got away from me. I'm still going to be looking up whether LTD income is going to count when determining your eligibility for the Canada Disability Benefit that is coming out. So that's something I'm going to be looking at. Maybe I'll know by Thursday. We'll see. I thought I'd be able to do it today, but things kind of got away from me today. It's important because we want to know if people on long-term disability are going to be able to get, they're going to be able to get the Canada Disability Benefit. That we're not sure yet. I mean, in theory, you could, but it will depend on what your income is. All right, here's another question. Put this up here, and I'm just going to get a little drink of water. If someone gets terminated and gets severance pay, is that an offset for long-term disability? The short answer is probably yes. It will depend on each policy. You have to look at each policy individually because each policy can have unique wording. All group policies have a section that deals with what things can be deducted from your LTD benefit. And most of them will have employment income written in a certain way. Now, there have been court cases in the past that said, depending on how it's worded, they may not be able to offset it. There's a famous case. I think it was worded as a certain way, and I can't think of it off the top of my head, but basically it was worded in a way that it would not include severance. It could deduct income. I don't know how it was worded, but it was able to deduct some employment income, but it was not a broad enough definition to include severance pay. So that case, the insurer was not allowed to. Now, promptly after that case, the insurance companies all rewrote their insurance policies to make sure they close that loophole. So unless you have a very old policy, it's likely that loophole has been closed. So they're very good at wording the policy so that it can deduct almost any type of employment income. The way they word it now is income from your employer, so that can cover like employment income, severance payments. They've worded it very broadly now, so it really covers everything. But yeah, it puts you in a spot where we often tell people what'll happen is like you're entitled to severance, but if you get it, your LTD benefits will essentially just stop for the number of months covered by this severance. Severance is usually calculated as so many like weeks of employment, right? It's like you'll get paid, let's just say 25 weeks of severance pay. Well, for 25 weeks, you would not be able to get LTD most likely. So what happens is your LTD pay just gets suspended. You get these payments, and you may net a little more money. Like you may get marginally more money by having your LTD benefits stop for a few months and get the employment pay. But after the employment pay, you take off taxes and everything. Sometimes it doesn't work out to much. So it's just not worth the hassle of having the disruption in your LTD. But that's just something everyone has to try to figure out for their own situation. Lee wants to know if I recall the court case. I don't off the top of my head, but I certainly could find it. And I can find it and mention it on a future show that I can do. And I don't recall the year. Yeah, it'd be like, it's an older case, so it could have been like 15 or 20 years ago. I think of everything as just a few years ago, but reality, it's probably like 15 or 20 years old by now, that case. Okay, let's see if we get any more questions come through. Yeah, just having a busy week. I'm trying to finish off. I've been working on a brief that I'm writing for the Social Security Tribunal in the CPP disability case. So that is always a lot of work. And I'll be working on that this evening to finish that off. All right, so I'm going to give a little plug to my book here while we've got some time. This is my book on long-term disability, the step-by-step guide. It's fresh out this year, came out in January, I believe. It's an update of an older book that I had that's been around for years and years. This is a way upgraded version of that book. And this is written specifically, as you can see up here at the top, employees with group disability insurance. So it's very much geared towards group disability policies. And I have a different book that's geared towards people with private individual insurance policies. So this one is the one that most people want to get. I go through 11 mistakes. One of those 11 mistakes is the what the topic is today of failing to do a return to work when it's recommended. And that book has a whole, it's not a chapter, but part of the chapter that goes through the 11 mistakes. One of them is failing to do a return to work when it's recommended. So it will cover a lot of what we talked about today. This book will also cover all aspects of the claim. So it is kind of a step-by-step. It takes you through like before you apply, during the application, appeals, what happens after you're approved. And there's parts in there about dealing with lawyers and settlements and all that stuff too. So for Friday, we haven't worked out all the details yet, but we are going to be talking on the topic of mediation between Lisette and I. Lisette's done more mediations than anyone else in the firm just because of the nature of how things work. I have a management role, so I've spent a lot of my time doing management and things like this, whereas she's 100% doing just disability claims 24/7. This book, oh, sorry, Lee, this book is available on Amazon, so you can buy it there. But you can also, if you don't want to spend money on Amazon, there's a link in the description down below. You can click on that. That'll allow you to download a PDF version of this book. Once you download the PDF version, you'll also get the opportunity, if you fill out your mailing information, we'll mail this to you for free, along with, we have like a kit that we send out. So when you fill out the form, it asks you different things about your situation. And depending on what you put in there, we send different things that go in a package that goes along with this. So for example, if you're doing an appeal, I think our package would include like a checklist for appeals and this kind of stuff. Now, just so you know, like why would we give this book away for free? Well, it's nothing in life is free, as my mother always told me. I'm like 51, so I grew up in the back in the 80s when these sweepstakes, I don't know if there's any other 50-year-olds here. If you remember those, it's illegal to do now, but you'd get these things in the mail saying, you have won $10 million. You just need to fill out this form and send, like, it was all a farce. Like no one had actually won $10 million, but my mother used to tell me, stop it with these. Stop getting excited. We have not won $10 million. So, but nothing is free. So this is not free. We send it to you for free, but you're giving us your information. We will also, we mail this to you, we put you on our print newsletter. So we send out a print newsletter about, I think it goes out 4 times a year now. You would get that in the mail 4 times a year. So what you're giving us in exchange is an ability to stay in contact with you and to mail you our print newsletter. We do that to maintain relationships with people so that if in the future you ever need a lawyer, we'll be the first ones you think of. Or if you ever have to refer someone, we'll be the ones you think of. So that's kind of what you're giving in exchange. And if you get the print newsletter and you don't like getting that in the mail, you can always unsubscribe to it as well. So we have 2 newsletters. We have our print newsletter that goes out quarterly, and we also have our email newsletter that goes out, I think, every Monday. We changed the date. It used to be on Wednesdays, I believe, but now it goes out every Monday. So those are the 2 things we send out to stay in touch with people. But if you don't want any other problems and you want to spend money, yes, you can go buy this on Amazon. All right, folks, I think what I'll do is end it there if there's no other questions. I thank everyone for showing up. Thank you for your questions. I will see you back here tomorrow. Take care.